The Federal Arbitration Act, this is really what created the conflict with California law here that brought this issue to the U.S. Supreme Court in the Viking River Cruises case. Now, the FAA, it's federal law enacted by Congress in response to judicial hostility against arbitration agreements. Courts didn't like arbitration agreements, so Congress passed this law, and it requires courts to enforce arbitration agreements as they're drafted. And it's to free up the courts, get these cases into a streamlined proceeding, less formal, usually quicker, and a streamlined proceeding that parties can agree to. There's more confidentiality in arbitration as well. And the U.S. government passed the Federal Arbitration Act, saying we've got to get courts to abide by parties' agreements to arbitrate cases. Now, the issue, though, too, that it came up in Viking is this equal treatment principle, where the court is saying, the U.S. Supreme Court is saying these agreements to arbitrate have to be treated the same as any other agreements. And a court can't say that arbitration, just simply because the parties agreed to go to arbitration, that it's invalid. So and that's really kind of the crux of the conflict that's coming up here in Viking that the parties are arguing over is, well, is California law under PAGA interfering with the Federal Arbitration Act and preventing parties to go to arbitration when they agree to it in an arbitration agreement? And obviously the FAA preempts state laws that interferes with this purpose. So the FAA in Viking, the court discussed the issue and about arbitration and explained that arbitration is not ideal for class claims. It's a more informal proceeding. It's quicker. It doesn't have the mechanisms in place to deal with class claims, class actions, or multi-party litigation if you've got 100, 500, 1,000 employees. So the court in Viking was explaining and setting out that as a result, these class procedures can't be imposed by state law without presenting unwilling parties with an unacceptable choice between being compelled to arbitrate using procedures at odds with arbitration's traditional forum and foregoing arbitration together. So the U.S. Supreme Court is basically saying a state like California can't set up this framework under legislation such as PAGA that basically gives the parties this choice between arbitration to arbitrate in class proceedings, or don't arbitrate at all and litigate the class proceedings or representative proceedings back in civil court. And that's really the crux of the decision here in Viking.